Hi, this is Professor Chad McGuire, and we're here to talk about and overview some of the introductory concepts of ocean policy and law. Some of the goals that we'd like to go through in this introduction are, first, looking at large bodies of water in the United States and attempting to understand the policy dynamics through a lens of legal frameworks. So what we're doing in ocean policy and law as a subject matter is we're looking both at legal frameworks. Legal frameworks are both the end result of policy. If we think of policy as a process where we legitimate ideas, government legitimates ideas and concepts and choices through the process of creating laws, statutes, and that's the formal legitimation of policy. So we have these legal frameworks that are both the end result of policy, and they also help to drive government decisions. For example, once government makes a law, that law sets into place certain expectations, so often mandatory expectations of government. And once those mandatory expectations are set, then that in and of itself constrains future government choices. Think of the Social Security Act, for example. It has had a profound effect over a period of decades on how government thinks about its social welfare programs and how it operates from a fiscal perspective. Government spends approximately 25% of its budget, annual budget, on paying for Social Security and specifically just Social Security retirement benefits and associated benefits. So the fact that that law exists both creates over time an expectation that Social Security is something that government is obligated to provide to its citizens, and it also in many ways constrains other government choices, because we always have to step back when we're talking about policy, and we have to think of the world as the policy world as a world of unlimited choices with limited options. So there's an unlimited amount of things we can do with finite resources. Government doesn't have unlimited resources to do all the things that it might want to do. So it has to choose between unlimited amounts of choices. It has to say, well, I know that we can do 10 things, or we would like to do 10 things, but we can only afford to do 2 of those 10 things. So when we have an existing legal framework that sets a policy direction, like provision of Social Security, then that has an effect. It has an effect on what government does in other areas. Our defense spending is another example, and our defense spending isn't necessarily, certainly all of it isn't mandatory, far from it. A lot of our defense spending is discretionary, but it's also something that, because of our previous actions and commitments and activities, we've come to a point where the amount of money we spend on defense is relative to the obligations and expectations that we've created both for ourselves and around the world. And that has an effect. Even though there are not mandatory frameworks, there's a US constitutional provision that says that the federal government shall provide for the general defense of the nation, but otherwise it doesn't give explicit instructions on exactly what percentage of government income or expenditures in a given year that must be, so on and so forth. There's a lot of choice in there. But the fact that we can look at this 2 ways, the fact that we've created previous actions and historical expectations that affects how much money we spend on defense, and also the fact that we spend money on social welfare programs. Almost half the budget is set aside. Half of government's annual spending is set aside to provide for social welfare benefits. We think, again, we think of Social Security, but there's also Medicare, Medicaid, and other programs that government spends significantly on. And those create a kind of what I call path dependence. They affect the amount of available money for doing other things. That includes defense, but defense in and of itself also does. So we have these legal frameworks, and we have also these dynamics of policy. And the dynamics of policy are ever changing. Whereas some of these laws, they get sort of even though our laws, our legal frameworks outside of constitutional protections, even those are subject to change, very difficult to change those, and they really don't Many of the federal laws that we have are certainly subject to change. Some of them have been amended, some of them have been repealed, some of them even have sunset provisions that if no new laws passed by a certain date, then the law expires. So there's a number of mechanisms that affect some of our legal frameworks, at least if we're talking about the statutes of our legal frameworks, not necessarily constitutional protections and other provisions in the US Constitution, but those statutes are subject to change. But many of them, once they're in place and once they become sort of accepted in the greater public mindset, they really are sort of set in stone. So while they might not change nearly as much as the whims and desires and choices, whether that's the citizenry making choices, special interest, depending on what sort of policy model you might choose, a way of thinking about how government makes choices and what affects government choices. The dynamics change, but the legal frameworks tend to stay the same. So when we're looking, what we're doing here in ocean policy and law is we're looking at both those policy dynamics that are dynamic, and we're looking at them in relationship to the legal frameworks that exist. So one thing that's certainly an issue that's affecting ocean policy and law, certainly, I mean, it's affecting it all in the ocean, but certainly along the areas that humans tend to be most acquainted with is where the water meets the land, is we have sea level rise. Sea level rise is a consequence in great part through the experience of climatic change, where the observed climatic change that we've been observing and studying and understanding over the past number of decades. And we're seeing the effects of that. And one effect of climatic change is sea level rise. And sea level rise has a significant impact on that intercoastal area, the area where the water meets the land. So there's a lot of policy dynamics surrounding this, a lot of sort of ideas and thoughts, and as we're seeing new information come in. Now, of course, those ideas and thoughts, they will run up against legal frameworks, and many of these legal frameworks are both statutory and at least in terms of the United States and ocean policy and law, we have a lot of common law doctrine. We have a lot of not statutory law, but law that is commonly accepted, that some of it is imbued into statute, but much of it is also, especially when we think about rights and obligations along coastal areas, property rights, those sort of things, we've inherited a lot of those traditions of law, the common law, not necessarily statutory law, mostly through English common law doctrine, but there's some variation of that. But the point is, we have these sort of rules of the road and ways of understanding rights and obligations that over time will impact and influence the way in which we think about sort of policy options. They might create options, they might constrain options, and that's sort of what we're talking about here in ocean policy and law, is looking at this writ large, all of these dynamics put together. We're going to pay some special attention to physical boundaries that establish jurisdictional boundaries. So this is really about those legal frameworks. So we're going to look a lot, we're going to start with these sort of boundaries and frameworks because they're really important, because a lot of the policy dynamics that emerge come from these physical jurisdictional boundaries. So understanding those legal frameworks, those base legal frameworks, help us to then start thinking about some of those policy issues that might arise and see the interrelationship. For example, if coastal states, Massachusetts, where I'm located, if coastal Massachusetts has jurisdictional rights in ocean water, right? So Massachusetts has rights that exist somewhere from where Massachusetts landmass ends to where the ocean water begins. How far do those rights go? Where do they go? And is there a point where it stops and then some other right exists, like federal, right? Does the federal government have ocean rights? And do those ocean rights from the federal government, do they exist only for the federal government? Does the federal government's rights, are they impacted at all by the state rights in water, if it has ownership rights in water? Or does the federal government have rights that extend beyond the federal boundary wherever we can identify and into state rights. Are these rights, do they have overlapping rights? Does the federal government and the state both have interests in property rights and therefore in policy? So we can imagine a situation, for example, where Massachusetts wants to do something in an area that it has an ownership right. And the thing it wants to do is related to a policy initiative that is important to the Commonwealth, important to Massachusetts. But the federal government might also have rights in that same area. And if it does the federal government have the same sort of, policy priority as the state, as Massachusetts, or does it have different priorities that might conflict with the state's wishes? So if the state wants to do A, does the federal government want to do A, or does it want to do B? And is B in direct conflict with what A is? And if there is a conflict, does Massachusetts have priority in its policy choice or policy desires, or does the federal government's priority trump Massachusetts desires and rights, or vice versa? Or is there some sort of way of thinking about this where you can meet both parties' rights, where you can sort of try to harmonize so that you don't create a direct conflict? Or if there is a conflict, who wins? Who has the greater say and priority over those areas? So these physical boundaries really help to start us understanding many of the policy issues. They can help define many of the policy dynamics and issues. So this is the match between the legal frameworks and the policy dynamics, and starting with physical boundaries and jurisdictional boundaries helps us understand where we can start looking at some of these policy dynamics. And that's exactly what that says. So jurisdictional boundaries create the foundation for identification, analysis, and evaluation of policy issues, literally how we engage in policy. What is a policy question? How do we analyze that question? How do we frame it? And then how do we evaluate some of these policy questions? As far as an approach, we're going to start with an understanding. Once we have those legal frameworks, we have a base understanding of those legal frameworks, which will continue throughout. That's a never-ending sort of desire and goal, is to really understand those legal frameworks. But once we have that, we're going to start with an understanding of the policy picture presented. So those legal frameworks we'll be trying to understand all the time. So because we can't just get those legal frameworks down and then start thinking about the policy picture, we're going to always, as we're learning and thinking about those legal frameworks and those sort of property rights and areas, that sort of thing, the sort of law aspects, we're really going to also complement that with the large-scale policy picture presented. Once we understand that policy context, we're going to come back, and as we're examining these legal frameworks, we're going to come back to these legal frameworks and try and see how they influence, just like I was using the example of Massachusetts and the federal government. If there's a line that delineates federal rights versus state rights, for example, generally speaking, but those rights otherwise probably overlap in many areas, then we're going to have those legal frameworks down, but then that will then help us understand some of the policy sort of conundrums or policy issues. So we're going to be, even though we want to understand those legal frameworks, we can't just wait until we fully understand those legal frameworks, maybe, before we start thinking about the policy. So our general approach is think about those big picture policy issues, and then kind of keep coming back to these legal frameworks that apply to the policy area. And then with the policy picture and the legal frameworks identified and contextualized, then we're going to start implementing some of these analytical tools that we can apply to gain a greater understanding about the issue. And those analytical tools are a mix of some of the legal dynamics, some of the case law that is interpreted rights, so that we can understand when one right might trump another, or we think of, I've been using government to government, state government, federal government, think of private property rights. When private rights, think of private coastal rights, when those rights must give way to the government interest that's at stake. for example. So if you're a coastal landowner and your property abuts the ocean, for example, and that's a really important thing because you own, let's say, in the coastal state that you live in, let's call it Florida. Let's move away from Massachusetts and Florida. And it's really important for you to touch the water, so that your land, your private property runs up to where the water, let's say at, I don't know, whether it's high tide or low tide, let's just call it high tide, right? Because there's a difference. There's that we all know that all ocean water has tidal ranges, and we know that at low tide there's more sand exposed, that wet intertidal area, and then at high tide there's less sand exposed. It's usually just the dry sand, if you can think of this, if you've ever been to the ocean. So where does a private property owner own to? In some states they might own to the high tide, the average high tide, so where that dry sand is, and that's where the private property right ends. And in other states, they might own all the way down to the low tide, which includes that intertidal area. And that really matters because you can think about this. If the federal government or the state government or government in general owns that intertidal land, then it's entirely plausible that you have rights of access for citizens, for the public, to that area, that strip of land, that intertidal area of land. Or if they don't, if the private landowner owns all the way down to the low water mark, then they can do a lot to prohibit private access, because you can imagine if you purchase at a premium a coastal residence that abuts the ocean water, then you certainly, one of the reasons you paid that premium is to have, is to be able to prohibit access, right? The right of exclusion, as they say in property law. It's one of the most important rights of private property, is the right to exclude others. If you didn't have that right to exclude other other citizens from your property, what's the point? Why would you pay for it? There would be an upper limit. So it's one of those of the many bundles of rights that we talk about in private property or real property law. It's one of the most important rights, the right to exclude. So of course, you're paying in part that premium to exclude others, but what if that exclusion is limited? And for example, imagine a scenario where they say, well, you own down to the low water mark, or even the high water mark, right? But now what's happening is that, sea level rise is occurring. And so that water is moving closer and closer through, relatively speaking, natural. Certainly there's the human writ large, moving carbon from a stored underground state and putting it into the air through our drilling and oil and is certainly having an impact and influence. We're putting more carbon in the air, which is then creating a greenhouse effect, which is warming our planet, which is allowing both thermal expansion of existing seawater and for ice melt and others to increase the amount of overall water in our oceans. And so therefore we have sea level rise, and it's occurring, and it's been measured. It's occurring globally, and some places it's occurring faster, at a faster rate than others, from a number of dynamics, a number of geomorphological reasons for that, and other physical reasons. But putting all of that aside, the idea is that, well, that sea is rising, so that water is slowly marching landward. So you're losing some of your dry land. And the question is, well, do you own that land? And if you're in Florida, for example, if the government comes in protecting, the government owns, let's say, submerged land. And, so any land that is underwater is publicly owned, and the government manages that land as trustee under the public trust doctrine, let's say, some sort of legal doctrine that might be both common law and maybe statutorily created, or, put into from common law to statutory. But these are legal concepts we can precise. But the point is, the government, let's say, is the owner of that submerged land. And so now the government takes action in order to protect against the march of sea level rise landward, and it comes in and it lays down a lot of sand, basically creates what's called a nourishment project, nourishes the beach to maintain the beach, and in so doing creates a large strip, pushes that water back seaward. And then the question is, hey, do I, the private landowner, own that land, that newly created land from your nourishment project where you've added sand and basically built up the sandy dry land to push the water back away from the land? Do I own that land, or does the government own that land? And that makes a huge difference, because if I own the land, then I have the value of where my land touches the water, versus where if the government now owns that land, then I no longer have that value. And most importantly, it's obvious if the government creates and maintains and enforces public access to that strip of dry beach land. So whereas I could have put up a fence and prevented people from coming onto my beach, that goes my private property that includes the dry sand beach all the way down to the water, there is now a strip that the government has created where I no longer own, and it's public and the public has access. So I no longer have my property touching the ocean water. And that has a huge implication. So we can think about these. This is a good example of where the law and legal frameworks then influence existing conditions that we see through the choices that we make, that government makes. So if government in Florida decides to go ahead and nourish that strip of beach and go and lay down that sand in that area, and now the effect of that is to remove my private property right from touching the water, then I lose a significant amount of value. And that has an impact. It has an influence. So government's choices and its choice to do that. And now government might say, we're doing this in order to protect your house from the approach of sea level rise, so that water's further away. The next storm won't be so close to your homes to cause damage, to protect, not just your house, but all of the houses along this area, and maybe also to protect some of the beach, because we need to ensure, because we're Florida and tourism is important and people love to come to the beaches in Florida. So we're protecting a number of things that are certainly within our 10th Amendment rights as a state, to protect our public interest and our state interest. In tourism, for economic activity, in the properties, the properties of our citizens, that sort of thing. So you get it, it can be very complicated. So we're going to start thinking about, in these examples, some of the analytical tools that we develop and understand about ocean policy and law, both from the legal frameworks and from what's going on, what's happening in this dynamic area. And so, some of the ways, some of those analytical tools that we talk about in public policy are things like alternatives analysis, benefit cost analysis, cost effectiveness, outcome output. There's many, many, many different sort of ways in which we can, or analytical tools that we can apply to our approach. So just to get a big picture of what we're talking about, at least in terms of lines, we can look at an area, a coastal area that runs into the ocean, and we can just take a cross segment of it and we can start dividing it up. And we can think about it in different types of, and these lines to start divvying up sort of generalized property areas. And now they're, in terms of a sort of a geomorphology, just in terms of identifying different areas, natural areas, we can say, well, we have an upland area for sure. And the upland is area that really never gets wet at all. It's upland, well upland of, our coastal area. Usually in most coastal areas, the place between the upland, the sort of green grass upland, and it's not just green grass or forested area where you have larger, more sort of woody perennials, et cetera, but there is usually a line of vegetation, and that line of vegetation has, you've probably seen this. You might think of dune beaches with some seagrasses, some spartinas, or some, we have here, we call it, there's a number of things in coastal Massachusetts, at least in the South coastal Massachusetts, but also all along the coast, where you have things like marsh elder and some other sort of these sort of long-standing sort of bushy hardwood, short, that help to define sort of a natural feature of vegetation. And that vegetation runs right along what would then begin to be sort of the dry sand. So the delineation between the beach, the sandy area, and before you get to sort of the upland areas. And I know in most areas, because they're so, at least the developed areas, you'll usually have a road most people will usually identify the road. It's like there's a road, maybe there's some, if there's some sand dunes, there's some vegetation line, and then there's the sand in the beach. But many areas that vegetation line is gone because we built a road, landward of that vegetation area, and now it's just sort of sand, road, and then uplands. And that happens a lot. And many of you might know this if you go to these places, depending on which coastal state we're talking about and how much development has occurred. But anyway, we have an upland area. We can say there's a vegetation line. We can say that there's a dry sand, and then there's the high tide line. That's where the sand gets wet at high tide. It gets exposed at low tide, and that's the wet sand area, is that intertidal area. And then we have a low tide line, and that's where at the low tide where the water meets the wet sand or the sand, water meets the land. And then we have from a low tide line, we have some distance out, and we can call that state ownership, moving left to right. And then from state ownership, we have some further distance where we have federal territorial sea. That's the federal waters that are strictly, exclusively federal property. And there's a lot of restrictions where the federal government, national government can restrict and exclude other nations' vessels, where we have the most interest and most protective interest. And then there's some additional area that keeps continuing out further to sea called the exclusive economic zone of the nation. And there's generally speaking less restrictions, but then after that exclusive economic zone, I don't have the line there, but normally that tends to get us into what's called international waters, waters that are not owned by any nation. They are literally international waters. And that's basically it. But we can think of this sort of dynamic and start seeing these lines along this sort of spectrum. And when we do this, we can look at that same spectrum, slightly different, but we can start giving it a little more definition. And we can look at these definitions as legal frameworks. We still have our upland, we have our line of vegetation, we have our dry sand, again, moving left to right, wet sand. Now we have these state waters. And approximately, we'll call them miles, nautical miles, slightly different. It's slightly different in terms of distance, but the state waters are approximately 3 miles from that a line of demarcation, an accepted line of demarcation of where the water meets the land. That moving outwards is 3 miles. So states have a strong interest, a very powerful, strong interest in the what happens in the waters that move from the land to 3 miles out, which is pretty significant. It's not the longest distance, but it's pretty significant. So coastal states, like I was mentioning, Massachusetts, Florida, any coastal state, many of them that sort of hug both sides of our country, including and certainly Texas, those state waters have 3 miles. There is a territorial sea that exists from that same wet sand or dry area to 12 miles out, and that's federal government. The federal government, has an interest, and that interest overlaps. That 12 miles is not 12 miles after the 3 miles, it's 12 miles from that, wet sand, where the land meets the sea. So there's a lot of overlap between federal interests and state interests between the 3 miles through 12 miles. But the federal government has the most interest in its national waters from that where the water meets the sea to 12 miles out. And it also has its exclusive economic interest from where the water meets the sea all the way out to 200 miles. And then beyond that 200 miles is international sea. Generally speaking, there are some variances that we'll get into because there's, depending on the geomorphology under the water, depending on how far the continental shelf, sometimes it drops off quickly depending on where you are. In the Atlantic less so, in the Pacific more so. And if that goes further than 200 miles, if it's then maybe it's a bit more, because it's or it's at least 200 miles. The exclusive economic zone of the country of the United States is at least 200 miles, and of other countries as well. And then international sea through international agreement. And there's a whole international accord, the United Nations Convention on Law of the Sea, that most coastal nations have signed on to, UNCLOS. And we'll read a little bit about that, and we'll get into more details there. There's a plethora of, these are courses. UNCLOS is a course onto itself, international agreements, etc. So there's a lot going on here, but our job is to understand these, these sort of lines, give these lines some definition, and then also think about some of the policy issues that arise from this. So one of the things we can do is, once we understand this as a general, and there's a lot of detail we need to get into, but just for introductory themes, once we understand these general relationships, then we can start thinking of these two lines below, and we can say, look, on a spectrum, moving from right to left, where you see the arrow at the top, legal framework definition, where the amount of legal frameworks, the amount of law, the amount of laws that are passed that create complication, let's say, laws that can interact with each other, that can conflict with one another, and a lot of sort of legal definition and interest that's involved. It moves from, when you're in international waters, it's at its lowest. And of course, as you move further and further into where humans, whether they define that as national, now you have federal law apply, the exclusive economic zone up to 200 miles at least. You have even stricter federal rules and regulations applying in the territorial sea. Now you have not only federal law, but you have state laws that start applying in the state waters. Now you have private property rights, for example, more complicated, more convoluted laws, because more humans live on land, and certainly no humans really live in the water, if you do in different ways. But now you have more complexity at the wet sand, more complexity at the dry sand, more complexity, more so complexity at the vegetation line, and the most complexity, the most amount of laws that have the opportunity to interact with each other at the upland. So that's what that means by legal framework definition, moving from low to high. So an alternative, on the other side, we can think that policy options. So when you have more legal framework definition, more laws that interact with each other, the degrees of freedom in terms of when thinking of, hey, what can we do? What are our options? How open is this field to new policy directions? It is the least open when there are more laws that apply, and it is the most open when there are less laws that apply. So we can see this sort of inverse relationship from this standpoint between legal framework definition and policy options, at least in terms of degrees of freedom. We have less policy options when there are more and more legal frameworks, and we have more policy options when there are less legal frameworks. So that's a really important thing, a concept to get into our heads at the very beginning here, which is when we are thinking of upland areas, when we're thinking of a lot of legal frameworks existing and coexisting in the same space, then we have really, in many ways, less policy options available to us because there's already so much of that space taken up. It's already been, many of those policy options have been either filled or they're excluded from the existing legal complexity or legal framework complexity. And then there's, of course, the other side, whereas while we're in the international waters, we have the United Nations Convention on Law of the Sea. That's great. Let's look at that language, a lot of that language, in order to get nations to agree when they otherwise do not have to. There is no obligation for them to agree about how they act, how they self-limit and act with each other in international waters. You'll see that there's a lot of room for a lot more definition, a lot more policy degrees of freedom, because there's such limited legal definition. Most of the agreements that we have at the international level on international waters there's a few that are obligations. Most of them are, they don't have much what we would call teeth in terms of enforcement. They're mostly, aspirational in nature. If you think of climate change and the international agreements we have on climate change, like the Paris Accord, and even more recently, what's occurred over in Scotland, they are at best implementations of getting nations to agree to do the best they can. They're not really mandatory. There's no real strong mandatory targets. There's no strong enforcement mechanisms, penalties, etc. It's really about trying to get the most agreement through requiring the least amount. And the reason why is because there's very low legal framework definition in those areas. But On the other side of that, there's the most amount of policy that can be new policy directions that can be applied because it's just like it's wide open. It's wide open because there's not many obligations. There's not a lot of legal frameworks that are going to constrain policy thinking in this area. So if you're thinking of where can we get the biggest bang for our policy buck, it's definitely where there are less legal framework definitions. And if you're thinking, boy, how hard is it going to be to implement new policy directions when there's a lot of legal framework definition, it's the most difficult. So that's a really important sort of conceptual framework to understand when we're talking about ocean policy and law issues. In terms of policy development, let's think of this as policy development evolution framework. Here, what we have effectively is the policymaking process. And we can think about this in this context that's presented before you in terms of management plans, for example, like implementing a management plan, a new policy direction related to ocean and policy, whether that's coastal, that sort of thing. And so we can look at this and we can say, well, looking at this writ large, putting it into practice, we can see here, let's think that we want to do some management on a coastal resource. We want to prevent sea level rise. There's many different contexts you can apply this to, but just think, we're going to try something. We're going to try something new. We're going to try to implement a management plan in this area. And the management plan is related to some ocean policy and law context. So we develop the management plan, think about what we want to do. We're going to implement that plan. We're going to evaluate it once it's implemented to see, is it meeting its, it has intended goals and is it doing what it's supposed to do? We can be very descriptive about it. And then through that evaluation, we're going to learn something. And then from that learning, from that evaluation, we bring ourselves back into the develop, whether we continue to develop and redevelop the management plan, and that's stated down here in the purple, which is adapt the management plan based on what has been learned. So in other words, hey, this worked really well. So we had 5 goals in our development of our management plan. We had 5 sort of things that we wanted to accomplish. And what we've noticed is that we've done really good at accomplishing 2 things. We were okay at accomplishing the 3rd, and we really didn't come close to accomplishing the 4th and 5th thing. So now from that evaluation, we learned that really good at 2, not so good at the 3rd, and really bad at 4 and 5 of the 5 things we wanted to do. So we learned from that, and then we redevelop through an adaptation our management plan. And we have a new management plan developed based on what has been learned in previous attempts. And so that's that sort of cycle. To put it into the policymaking process, we can say that developing a management plan is like setting the agenda and formulating some policy approach. Then we can implement the management plan, in part legitimize the policy, right? So legitimization can occur formally as a statute, if we think about sort of, whether it's in the federal level, Congress taking action, right, legitimizing a policy, or if it's more local, this is maybe an ordinance. If it's regulatory in nature, it might be an agency that has been delegated authority to then create a rule in order to implement some sort of, legitimized policy. And that can happen at the federal level, at the state level, and even at the local level. Local planning boards, for example, reviewing plans, coastal management plans, if we're thinking of coastal issues, right? Siting of offshore wind farms. Is the siting happening, right? Where is it happening? Is it in state coastal waters? So does the state of Massachusetts want to put up wind farms within 3 miles, or does it want to put it out in federal waters beyond 3 miles, even if it puts it within the 3 miles, federal government? But the point is, you can imagine there are these different actors that are involved. And if we're looking at it from the policymaking process, we have agenda setting and policy formulation. And of course, Intro to Public Policy would help you understand this. And it's assumed that you either you will be exposed if you haven't already been exposed to this. But then we have formulation of policy, and then we start moving into the green, which is legitimizing the policy, implementing the policy through that, of course, implement the management plan. And then, of course, there's the evaluation of the policy. This is the policymaking process, policymaking as a cycle, as a process. And then, of course, learn from the evaluation of the plan, is policy change? And so that's our, the equivalent. If we look at this sort of policy development evolution framework related to ocean policy and law as an example, we can see it starting from agenda setting through policy change and vis-a-vis the policymaking process, just to connect those things. So in this neat thing, we can, what we're doing here is we're doing policy. And of course, in this course and understanding the law and many of these legal frameworks, they're going to influence how we set our agenda, where we can set our agenda. Are we looking more inland, where the existing legal frameworks is very dense, and therefore the amount of policy policy making discretion is limited because it's such dense? Or are we more outside towards, are we in state waters, federal waters, international waters, where there's more opportunities to at least propose new policy directions? As a matter of final thoughts, what we're doing in ocean policy and law, what is done in ocean policy and law, when it's done well and when it's understood, is we start with an understanding of ocean coastal issues. So we create a policy context, right? What are the ocean and coastal issues? And that helps us create the context for considering either new policy directions, evaluating existing policies, so on and so forth. And we understand the legal frameworks and overlay them onto the policy issue to contextualize the issue. So really important to get those legal frameworks, understand them fully, and then have them overlaid onto that policy issue. And many times, if we move inland, we might find, oh, geez, there's no room for this policy context, at least in terms of new direction. So let's look at what is being done, what has been done, and where some of those frustrations exist. And at the very least, we can identify where there's a policy problem, right? Where there's, geez, these current legal frameworks and these current policies are sort of running loggerhead at each other and preventing us from moving forward to deal with this new problem and new issue. It is literally hamstringing government. So government cannot take action on this new thing we found out because of existing frameworks and the limitation those existing frameworks create for new policy directions, just as an example. And then we can identify and use those analytical tools, those ways of evaluating and analyzing these policy issues to begin to understand and assess the relationship between the policy, whether that's an existing policy, a policy proposal, one that hasn't existed that we're thinking about, and the legal frameworks that we now understand. So that's the big scale, what we're looking at. And then finally, that helps us comprehend how our legal frameworks, these legal frameworks, how they affect our policy directions, existing and potential directions. So that's what we're looking at here. This is our big picture introduction. Hopefully now you have a better understanding of sort of the relationship between both thinking about policy related to ocean policy and the legal frameworks in ocean policy and law, and how those things are going to interact with one another, and how understanding the legal frameworks really helps to contextualize an understanding of existing policy and also, potential new policy directions. So thank you very much for your time. I hope you enjoyed this session and it was informative.